Mr. Hillygus is lingering in jail. It's not doing him any good. Every time I see him, he looks thinner and not as healthy as the other times I've seen him.
All rise. The Second Judicial District Court of the State of Nevada is now in session. Honorable Barry Breslow presiding.
Thank you. Good morning, everyone. Please be seated.
Thank you, Judge. I'd like to remain standing. I have some issues I need to address with this court.
You have some issues, what?
I would like to address with this court this morning, too.
Well, I'll hear from your attorney first, and then if he authorizes you to address the court directly, I'll entertain it at that time. But at this point, Mr. Handte, please have a seat. All right, let's identify who's all here, and then what we're here to do today. Then we'll take up whatever it is Mr. Handte would like to address.
Thank you, Judge.
All right, we're here on Mr. Hante's case, we're here on Mr. Hillygus' case. The court acknowledges the prosecutor, Mr. Amos Stege, Mr. Handte, Mr. Hante's counsel, Mr. Silverberg, Mr. Prasad, who has been appointed as standby counsel for Mr. Hillygus, and Mr. Hillygus himself.
And I'd like to also address the court when I have an opportunity as well.
Okay, we'll see if that's going to happen. Let me tell you what's on the court's agenda. Let's start with Mr. Hante's case, in no particular order, but we have the other acts motion that the state brought at the last hearing at the end of March, I recall. Additional time was provided to defense to respond to that. They have very resoundingly and compactly opposed that motion being granted. I recall from the prior hearing, the court said that after the opposition is filed, the state would have so many days to reply if it chose, and then submit, or if it chose to argue only, just submit it and we'd set it for a hearing. Procedurally, so let's just pause for a moment. Mr. Stege, has the state responded in writing? Does it plan to respond in writing? Do you want to submit it now, set it for a hearing? Procedurally, not substantively, where are we on that?
That's set it for a hearing, Judge.
Okay, so before we leave here today, we'll, among other things, set a hearing on the other acts issue. Writ of mandamus, I believe, filed self-represented by Mr. Handte. The court allowed additional time for supplemental briefing. Court indicated I would rule probably without a hearing. I didn't see any supplemental briefing from defense. Was that something that you intend to do and should respond to that? In other words, taking a look at what's been filed, do you want to add to it, supplement it in any way, or give it a little more further thought?
You're on right. Wasn't filed by your partner?
No, Judge, I filed that myself.
Yeah.
No, I found it sufficient.
Okay, and then the state was going to, I gave the state additional time to respond if it so chose, or would you just submit it and have the court rule?
Have the court rule.
All right.
I have already responded to that.
Got it. Issue of the Easter release. Now, I didn't mean to put everyone in a tizzy by the prior contempt order saying that Mr. Handte had to serve 4 weekends, that being 8 days, when I clearly said 7, and I was fully aware that the 8th day was Easter. I realized that gave heartburn to Mr. Handte, his family, people that care about him, and how could I keep him there into Easter. It was never the court's intention to do so. Luckily, it came to my attention, we straightened that out, and I'm hoping you are home for Easter, Mr. Handte.
Thank you, Judge. I appreciate that.
Yeah.
Thank you.
Yeah, and again, we weren't trying to upset you unnecessarily for something that should have been handled earlier. Mr. Handte, just a reminder, please don't email my staff directly, even on things that you're concerned about, frustrated about, trying to get clarification. Right now, Mr. Silverberg has that job to do that. He has been in a series of trials, one of which was in this department, one of which he had a very successful result, but when the jury came back with a verdict. So he's not, he can talk for himself, but I'm telling you, if it seems like things are taking a while for him to get back in touch with you, he's not off playing usually, other than a couple of scheduled holidays he had. It's because he's working here on behalf of other clients.
And I appreciate that, Judge. I understand his caseload. We've talked about that a few times, and it just seemed that the time frame was diminishing quickly.
Getting close. But and we could do a better job if we postpone something, and, the order should identify clearly what day, what time, and who's expected to all be here, so no one's going out of their way to trip people up in that regard. Now, Mr. Silverberg, your client wants to address the court on an issue that's clear, because when I took the bench, he was standing. Do you need a minute to bottom this out with him? Are you comfortable with him addressing the court? I don't mind hearing from clients from time to time if it's something they want to sort of get off their chest, as long as they understand court decorum and that they don't want to say anything that's going to injure their case or put them in any jeopardy, but really it's your call.
I would need just a little bit, this is the first time hearing of it, so I would need a little time to talk to him about it. It's not
As
something
in
I-
2 minutes of white noise in the background, or during a recess, or what do you think? Or do you even know the nature of what he wants to address?
I don't at this
All right,
point.
so then I'm not gonna let you, Mr. Handte, I'm not gonna let you just stand up and start addressing me directly, because it needs to be filtered, if at all, or at least run by your attorney. He's here to protect you. He doesn't want you to say something that the state might use against you. So I'll give you a chance to talk to him in a few minutes. I'll go off the bench and you can tell him what's on your mind, and then you can both come back and tell me what's going on. Everyone understand that?
I understand. I don't judge, like I said, I've researched a little bit of the court decorum and the rules and procedures of the court. And I would just reference to the Nevada Supreme Court Rule 2.6, and that's all I'm reference to. And it's not gonna be a long diatribe, just be a few things that I want to address the court to.
Okay, well, before you start telling me what those are,
I will say,
please run it by Mr. Silverberg.
correct.
All right, let's switch over to Mr. Hillygus. Frustrating that we are today where we are. Number one, the court only has one of the two reports that it is expected to have today. That's a concern. Second, the one from Dr. Loring indicated that Mr. Hillygus refused to engage. He would not respond materially or substantively to any of her questions. And so, although her default position was presumed competent, because the law says, in the absence of a finding, then it's presumed. But that's a nonsense. The whole reason the court directed Mr. Hillygus to be evaluated was because of concerns, particularly in a case like this where he's self-represented, that he may not be able to represent himself effectively and appreciate what's happening. And the fact that when we had our hearing several weeks ago, I thought Mr. Hillygus had agreed that he was going to cooperate in the evaluation process, but that did not apparently happen. And so it's very frustrating. So I guess one thing I would like to know from any counsel here, if they know, is when is the other evaluation report expected? And did it occur, even if it didn't go forward, sort of like Dr. Loring's? Mr. Prasad, what do you know?
So, Your Honor, candidly, I do not know when the next evaluation is scheduled.
How is that possible?
Well, I want to just kind of back up and give context to what's going on.
Sure.
When we submitted the evaluation request, it was around the same time the county switched over to using NAFCare as its sole provider for in-custody evaluations. As I understand it, there was an error at the beginning of the process. About 2 to 3 weeks later, we found out they didn't get any of our emails. So everyone, not just this case, but all cases had to be resent to them for evaluation. I was checking in on this during the process, partially because we also agreed to provide the state the name of the evaluators. At one point, I discovered that they may have believed this was a mental health evaluation. I tried to correct the record on that this was a competency evaluation. We did only receive one. I don't know if they ever understood that this is not just a mental health evaluation, but a competency that needs 2 evaluators. So we are following up with them right now, trying to figure out if they have another one scheduled. As of right now, I don't have that information available for the court.
Mr. Hillygus is lingering in jail. It's not doing him any good. Every time I see him, he looks thinner and not as healthy as the other times I've seen him. One of the goals was, I'm telling you, all of us what we already know, but it helps me to reiterate them so everyone understands how important the court views this. The key is to have a determination on whether Mr. Hillygus is competent to proceed. If he is deemed competent, then it's very likely that the role of standby counsel will be ended. Not guaranteed. I may still keep the Washington County Public Defender on as standby counsel in any event, but its role to this extent for sure will be changed, if not completely eliminated. the court will also entertain his custody status at that time. As we know, he's in custody now because he violated a court order to come to the courthouse to submit to these evaluations, and he fled, and we had to bring him back here. But the court takes no pleasure whatsoever in keeping Mr. Hillygus in custody pending this trial if he's competent to proceed to adjudication any longer than he needs to be. That's, if I haven't said it that way before, I do so now. That said, I need 2 evaluations, but let's sort of extrapolate from the first evaluation, the failure to engage evaluation. Let's assume the second one is stood up here in the relatively near future, and let's assume it's the same type of a report. What then? Because in the court's estimation, there are 3 options. Option 1, default position, he's deemed competent to proceed to adjudication. That the failure to engage is not dispositive of the question of incompetency. Option 2, the concerns the court have not, that originally led to the court pausing these proceedings and directing him to competency evaluations have not been addressed. And so the court by default adjudicates him incompetent and directs him to Lakes Crossing to be treated to competency. Option 3, court holds Mr. Hillygus in contempt of court for violating a court order to engage in a meaningful, to the extent he's able, meaningful analysis and evaluation with those that are seeking to evaluate him. Maybe there are other options, but those are the 3 the court sees. So one thought the court had in anticipation of today's hearing is to task the state and standby counsel to brief the issue of what is the court's authority and how they believe it should be exercised. Do the attorneys believe that those are the 3 options? And if so, which one should the court move forward with, assuming the second evaluation comes out with the same results as did the first? Understanding it might come out with a different one. But I want to know what you believe the law is, what the court's authority is, and what you would recommend so that when we have our next hearing on this, the court will make a decision after allowing some argument and considering these briefs, doing some research. Because I don't want to continually kick this can down the road. But I can't make any decision because I do not have 2 evaluations. The law is clear. And maybe you've heard me say this before, but my normal philosophy is when in doubt, follow the law. And in this case, the law says I need 2 evaluations, even if they're going to be a complete failure to engage. I only have 1. And I'm not attributing any fault to the defense. You've explained the circumstances, new provider, miscommunication. It wasn't just Mr. Hillygus' case. Apparently it was others. But let's move as expeditiously, as quickly as we can so that this case and this fellow don't linger. Let me pause there. Any comments or questions or concerns based on what the court said? Because at the end of this hearing, I'm probably going to say, how long does the state need to file a brief on what the court's options are and how you think the court should exercise them? And Mr. Prasad, same with you. And to the extent Mr. Silverberg wants to take a position, I hear it because he's joined at the hip right now with Mr. Hillygus, his client. What do you think?
I think we already have the answer. 178415 says after we get the appoint to get the evaluation. Now it's not clear, it's not strictly clear that you must have 2 evaluations.
Well, I read it as 2.
But you must at least appoint 2, and right now only 1 has been appointed. But assuming arguendo that it comes back the same, that in the way that he didn't do it in the first instance, the second instance, or the third instance, the fourth will be the same. The statute tells us, have a hearing at which the parties can decide whether to traverse the findings of the evaluators. I have an idea how that might go, but I think that is a clear path before the court. And then out of that hearing, the parties, of course, could suggest options, but
brief before the hearing to educate the court on what you believe the law is and how it should be applied here?
I'll tell you, I'm gonna cite 178415 and says we're gonna have a hearing and the court's gonna decide if the evidence supports competency or incompetency.
And your brief will say how the court should interpret a failure to engage finding
Yes.
of competency?
Well, and more important, the evidentiary hearing will engage the experts in, well, how is failure to engage, how does that show competency? And it would also include presenting them with evidence of competency outside a willful failure to engage, right?
So we've said
Such
that,
as,
okay, so other acts that are indicative of somebody who's competent to understand what they're doing, help themselves in their own defense, appreciate the nature of the court proceedings, et cetera.
yes, because within the field of forensics, both psychiatry and psychology, one of the sort of canons of those fields is to look at all available evidence. And I submit, for example, the hours of jail calls here with rational discussion of his defense and strategies, understanding of the parties, et cetera, especially given how low the bar is. I'm confident that that piece would be helpful to the court in deciding whether.
So you would play some of those, you'd make argument how the court should interpret that. The experts haven't been provided with any of the jail calls,
No, and that is why I wanted the names of the experts,
so you could get that to them?
so that, yes, between now and then, I would say, dear expert, can you please include this in your
And
analysis?
if it doesn't happen, then we have the experts here, we play
Yes.
it, we ask them to listen to it and say, what do you make of that?
Yes, and I think even if I did do that, I would subpoena them, I would want to engage them in examination on, right, how is it that if you refuse, you are saying he's competent? I think that would be helpful for everyone, but especially the court.
Well, right now, in the report from Dr. Loring, there's no line there other than the default position, right?
Right.
That there was no indication that this was indicative of somebody that understood the court proceedings, could defend himself, things like that.
Although I think there's also pretty strong evidence in the form of, he has no mental health history, right? Like that's the most
I saw that.
typical, the context for incompetency is your most serious mental illness.
Well, he did have, according to the report, some brain injuries, some other traumas, and other, it's not, the storyboard is a bit incomplete. But yes, I did notice that no treatment for mental health, illness, or challenges or deficits in his history.
Yeah.
So that's how you see it. So you would say, let's wait for the second evaluation, whatever it is, set it for a hearing, put it sufficiently far out that the state could subpoena the evaluators, then we'll block out several hours for the hearing, and at that time, the court directs competency or not.
Yes, and that is assuming, now, if they both come back competent, I don't want to traverse. I'm gonna ask the court to find them competent, but that's sort of assuming that from the defense perspective, they have a desire to traverse, but yes,
Or not.
or not.
But, the court can continue to be concerned,
Yes,
notwithstanding the evaluator's default position, notwithstanding that neither the state nor the defense chooses to traverse. So if we're going to get to that point, and even if you're not going, if the state's not going to traverse, and even if the defense is not going to traverse, we still want to set it for an evidentiary hearing, and I still would have the evaluators here, because the court would want to hear from them. Okay?
Yes.
We can't assume that the court could make an informed decision in the absence of that. Okay, so procedurally, Mr. Prasad, based on what the court said and the dialogue with Mr. Stege, thoughts, please. He's not in favor of he didn't say this, but the gist is, I don't need to brief this, here's my position right now. What do you think?
At this point, Your Honor, without seeing what the second evaluation is going to look like, I would concur with that position. I think a hearing on the evaluations, and if the court finds in advance of that hearing, it may need briefing on it.
Could order it, right? Could order it at that point.
Yeah, at that point, it can be ordered. Quite frankly, I don't know what's gonna happen in this second evaluation. I have seen some
Well, we
where,
don't even know who it's gonna be or when they're gonna do it.
And so I think at this time, I think that's an acceptable, holding the hearing required by statute is an acceptable resolution for me, from my perspective.
Neither of you are saying one of the options of the possible contempt for failing to engage. That's really not a thing in the view of the state.
It is a thing, but at the moment, I don't want to.
You wouldn't argue the court should explore that further.
No, I mean, he's in jail now, I predict he'd be in custody until trial.
Mr. Prasad, any thoughts on that?
No, Your Honor, I don't think a contempt finding is necessary, on these facts.
Okay. Anything you'd like to address based on what you've just heard, Mr. Silverberg, on this issue? And I want Mr. Hillygus to know that when we take a recess shortly, I'm gonna allow him the opportunity to talk to his attorney, in the event he wants to make a statement to the court that I may or may not allow, and at the same time, Mr. Handte can talk to Mr. Silverberg about the statement he wants to make. But on the issue that how we handle Mr. Hillygus' competency hearing, in light of we only have one evaluation, it was a failure to engage, and it will be likely an evidentiary hearing with the evaluators here when we get to it.
So, my thought is that it's not Mr. Hante's issue, and that we don't need to be a part of any evidentiary hearing. That would be between the
As an
court.
excuse, don't even need to be in court or need to be consulted on the date
We
or
don't
what?
need to be consulted on the date, we don't need to be present in court. I think the state would agree that that's just not our issue. In the interest of not being involved in a part that really doesn't pertain to us and with many other things to do, I would ask that we not have to participate in that process.
Okay, I'm not likely to excuse you or the defendant's appearance for that, understanding though that you're not necessarily gonna take a position or have a speaking role, but when I have an A and B case and what happens with somebody's competency on part of it, it's, to the court, has a relationship to the other side's case that I want them here, I don't want them to have to read the minutes or the transcript. So if this is a way of saying, Judge, if you get to this hearing, you're gonna either now deem this a request to excuse us, or heads up, one might be coming, I can tell you, it's very likely I'm gonna would deny that request.
Understood, I just wanted to make that record, because we just have no dog in that fight. And as far as the statement that Mr. Handte wishes to make, I have had an opportunity to discuss with him, what began as two issues, I think is just one issue relating to his GPS, and it's important to him to address the court on that. And
Okay, Mr. Handte, go ahead, if you don't mind, please stand up and tell me what it is with respect to that you'd like the court to.
Thank you, Judge. I want to address the court on this specific matter. First and foremost, I've lived in this town for 48, going 49 years. I've never been subjected to a character assassination, much like the state has done against me. There is no threats of me being a harm or safety to the health and risk of the community I've lived in for 48, 49 years. 30 of that was being a law enforcement officer, which I retired from in due diligence in honorable condition. Thus being said, I've researched the fact of the matter that these GPS monitoring devices are unconstitutional and illegal when the United States Supreme Court ruling surrendered in 2015, Grady versus North Carolina. Mr. Grady was a two-time sex offender. I did not have a criminal history prior to being arrested in August of 2019. Therefore, I think Mr. Grady had an even higher bar than I would. The case was heard in the North Carolina courts, and went to the North Carolina Court of Appeals, and then went to the United States Supreme Court. The United States Supreme Court overturned the North Carolina Court of Appeals and stated these things, GPS monitoring devices, and I'm only dealing with the tracking device, not the blood alcohol, the one where they trace, where somebody's been drinking, and they can pull up the residual amount of alcohol. These are just the tracking devices. The United States Supreme Court stated in 2015 that these things are unconstitutional and illegal, and basically said they're a violation of the Fourth Amendment. Again, there are some things that have been stated in court documents, and Judge, to you, if I came into your court, sir, and presented a document that I inherently knew was false and full of falsehoods and misrepresentations of facts, and you found out about it, and you brought me into your court and challenged me and questioned me on it, I believe I can answer for you right now, sir, with all due respect. I would be in trouble. I would be in trouble because you would say, Mr. Handte, did you provide this statement here to this court knowing it was full of falsehoods and misrepresentation of facts, and you had found out about that? That's what I'm saying. Everything that's been put forth in court-related documents pertaining to health and safety risks of the community, that have gone and badgered these witnesses, this all been erroneous information, Judge. I'm not a threat to this community. I've abided by the court rules and regulations. I did not want to appear for this GPS tracking device because I felt it was a violation of my rights, and subsequently I've learned that it has been. I'm willing to come to every court hearing. I've been coming to every court hearing. You found me in contempt. I did my time. Even though I'm sorry, I apologize to you in the court for pushing the issue on the 8th day. But I've done everything that's been required of me. I'm not leaving this town. But I feel it's very detrimental to my health, mental health, and physical health. Mr. Stege has already alluded to that. I have to put on hydrocortisone treatment every day or else I will get contact dermatitis. The other fact, Judge, is that when this device was attached to my right leg, it caused my right calf to expand. That calf is not deteriorated or not diminished in capacity. Something is happening to my right calf. I had to go to the hospital. I had the MRI done on it. Cost me money, $2,000 worth, Judge. And they didn't find any blood clots, but I've had blood clots in this leg when this thing was applied. Not to say my health is in peril right now. I think I'm staying in pretty decent shape, doing what's required of me in my job, and going to work out afterwards, work every day. But I feel that this court has not recognized the fact that this GPS monitoring device is inconsequential. It's not going to keep me from doing anything, and I haven't done anything illegal, nor would I do anything illegal to jeopardize your position as presiding judge in this court, or my positions, or my co-defendant.
Okay.
And I'm requesting that the court to please
Change it, you want the court to change its mind?
I want the court to change its mind just because I'm not going anywhere. I've lived here 48, 49 years. Despite what the state has said, I am not a risk. There's no police reports. I mean, there's.
Okay, well, hold on, Mr. Handte, you're repeating yourself.
I'm
So
sorry.
I get it, you don't have to hit me over the head with it.
No, I didn't mean to.
But let me say something else. I'm not tone deaf. I understand where you're coming from. The court has considered this issue 2 or 3 different times. The ruling has gone against you primarily on that issue. This is a sort of an ad hoc, I'm my own advocate, even though I have an attorney, and 99% of the time, I don't let somebody address me on an issue like this when they have a retained attorney or an appointed attorney. That's their job. Also, if you're saying, Judge, please reconsider, reconsider, because I want you to hear it straight from the horse's mouth. This is the guy you're dealing with. Here's what I'm going through. Here's the life I've lived. I get it. I get it. If you're saying, please decide right now that you're changing your mind, I'm not going to do that. I'm not going to do it. I've made my mind up. If your medical condition, I don't even need to make a ruling, but just so you have an understanding that I'm not oblivious to the concerns you have. I'm not. I just don't see the ultimate ruling your way. I found the rulings of the state more persuasive. And so telling me this now, while I hear you, it's not changing the court's ruling at this time. If Mr. Silverberg believes something has materially changed, for example, your medical condition changes for the worse, or the case gets postponed again, and the trial date gets moved, and you have a history of compliance, which, of course, you just got done going to 3.5 weekends in jail because you not only pushed the limit on those interviews, you went over.
But Judge, the
I-
Supreme
so I-
Court ruling.
So I'm not, I'm aware of the case law that governs this court's decisions. I'm aware of that. And I disagree that it leads to the same conclusion you're asking the court to make. But I can tell you this, these type of arguments need to be made by your counsel. Even if you're well-spoken, you are, even if you've spent a lot of time looking into it, it appears you have, even if you're passionate about that you're righteous and this is the way I should look at it, I get it. But I have to make tough calls every day on cases. And right now, based on the totality of the circumstances, the status of the law and your medical condition, I've ruled the way I have. Mr. Silverberg, anything else to add? Then I'm going to ask Mr. Handte to have a seat.
Judge, I appreciate the opportunity to speak to you this morning. I would just, one last sentence, I would just like to say that whatever information has been set forth to this court regarding my character and my demeanor and has been erroneously given to you by the state. And I will go on record, and if you want me to, I'll challenge it in every way, shape, or form. Because I've never made threats to kill someone. I've never done things that have been ludicrous statements in these reports, and that will what you base your decision on, Judge. And I'm here to state to you, that information by Mr. Stege and his boss is erroneous.
Well,
Thank you.
all right, got it, thank you.
Thank you.
Now, let's talk some more about Mr. Hillygus' case.
I'd
Mr.
like
Hillygus,
to-
before you address the court, I am gonna take a recess and let you talk to, and have Mr. Prasad talk to you.
I would like to address the court.
Well, I get that, because you're standing up and you wanna say something, but I don't want you to say anything that's gonna work against you. I wanna protect you from yourself, so before I hear from you, and it looks like, I'm showing some leeway here, a little unusual, I just want you to run by Mr. Prasad what it is you're planning to say to the court. So I'll give you some time here in a couple minutes, all right? But let's also go over where we are procedurally. We have to I'm gonna set another hearing date to have the competency hearing, because we don't have the second evaluation. When we set it, we'll make sure we have several hours. When we set it, the state is gonna subpoena the witnesses, because I cannot imagine I'm going to make a decision on this in their absence. I reserve the right to direct briefing, a 3-page legal memoranda on this issue from both sides, on what the court's authority is and how you believe the court should exercise it. I'm not gonna make that ruling yet, let's just see what happens on the second evaluation. So before we do anything else, date and time, Ms. DeGainer, please, where we have a 9 to 12 or 1 to 4, preferably in the morning actually, to have this hearing.
You sure? How much time before that hearing?
3 weeks, 4 weeks? What do you think, Mr. Prasad?
I think 3 weeks, and if,
If we need to
like
push it
last
back,
time, we find out the evaluation's scheduled too close to that hearing,
then we
we'll
need to
let the
move it
board
back,
know.
just make sure everyone knows the date and time if we have to move it back. We're not doing it for the purposes of delay, it's just so we can all be fully prepared. So roughly 3 weeks from now, I've back-to-back trials, like a lot of courts right now, but we'll make time, we'll take a recess from any other matter we have.
You sure? In 3 weeks, we are in trial that week, but the following Monday is open, that's May 15th.
Do it, we know if May 15 will work. For the state, thumbs up, Mr. Silverberg.
What was the date again?
Monday, May 15,
Just check.
okay, and Mr. Prasad, do you know if that would work?
May 15 works.
Okay. Okay, while he's looking, I'm gonna say a few more things about,
Well, Your Honor, I can do the 15th.
okay, good, thank you. 9 o'clock on the 15th. We'll block out from 9 till noon. All right. Let's move on. The gag order briefing, limited jail calls briefing. I saw this, I directed the Washington County Public Defender's Office to respond. So I expanded the scope of their role from just being standby counsel on a competency issue to standby counsel to also address things that would happen during the competency issue determination period, because the state was eager to have a court ruling to limit Mr. Hillygus' communications to only those necessary for the competency evaluation and his legal team, and not parties to the outside world, both who he talks to and jail calls, things like that. Now, the defense has responded. Mr. Stege, do you anticipate filing a reply? Do you want to argue it right now? Do you want to just submit it based on the briefs? How would you have the court handle it?
Submit it on the briefs.
Okay, is there any other point that the defense would like to argue that's not entailed in the brief?
No, I'm fine submitting.
Okay, so here's the court's decision. Status quo, now, written order to follow as soon as the court can get to it. I know it's an important issue to all sides. Custody status for Mr. Hillygus, I've already said my piece on that. We're gonna take a look at that as soon as we get the competency issue buttoned up. The contempt issue for failing to engage, that's way in the back. That is not anything the court would be looking forward to, seeking to hold Mr. Hillygus in contempt. The sort of still pending, but on pause motion to withdraw as standby counsel, because client doesn't really want that. The court's not ruling on that pending a determination of competency. So the role of the defense counsel remains the same pending further order of the court. Now, before I take a short break, come back and hear either directly from Mr. Hillygus or Mr. Prasad. You tell me generally what it is you believe he's gonna say, and I'll make sure it's not something that's gonna work to his disadvantage. Is there anything else the court has overlooked as of right now?
I have nothing at this time.
All right, thank you. How about Mr. Silverberg?
Nothing, thank you, Your Honor.
And how about from the state?
No.
Okay, we'll be in recess for approximately 10 to 15 minutes. I'll come back and we'll see where we are with Mr. Hillygus. All right?
All rise. All rise. This court is again in session.
Thank you. Please be seated. Okay, we're back on the record. I'm here with counsel and the two defendants. So bearing in mind that the court gave a little leeway to Mr. Handte, he wanted to address the court, wasn't exactly sure what the issue was and made an exception because he has some powerful things he wants to say, and occasionally I'll give a little leeway. You know, I'm going to hear from Mr. Hillygus in a minute, but I want to set the parameters and make some cautionary words after hearing from Mr. Prasad. One is that we're still in the stage where the court has concerns about Mr. Hillygus's competency. So whatever he says, if he starts to say things that in any way the court believes are impairing his right to defend himself or hurting his defense, that's going to be shut down instantaneously. Number two is the court has already, in other hearings, when Mr. Hillygus was self-represented, indicated it had concerns that he was saying things that were not relevant to the proceeding, may have violated court decorum and otherwise. So if I start hearing a particular view of the government, the Constitution, the rules of court, this court's ability to preside, things like that, it's going to be shut down also very quickly. And finally, if I get the sense that he's not listening to anything that advices counsel might have said or what counsel's here to do or impacting the competency proceeding in any way, that'll be shut down. But if it's something else, it's procedural, question about how we roll, anything that just a quick thought that I can respond to be respectful to his status, I'll hear him as I did with Mr. Handte. Mr. Prasad, what do you believe the subject matter is that your client is going to address?
My understanding is that Mr. Hillygus wishes to address the current competency report insofar as it says he did not participate in the proceedings of that report.
All right, well, I'll allow him to go into that. I mean, that's going to be the subject of the hearing we're going to have at some point. So, if he wants to sort of preview what the court might hear later, I guess that's probably allowable. We'll see where it goes. Mr. Hillygus, go ahead, sir.
Okay, I'd like to make a record, and I'd like to object to this hearing, for one. I'd like to object to the report by Dr. Loring as hearsay, claiming that I did not participate, which is false, and that I refused is false. I'm here, she is not, it's hearsay. I want that on the record that I object to that report. I object to this hearing for lack of jurisdiction, personal and subject matter regarding me. It's been challenged at this court. I've challenged the subject matter and the personal jurisdiction of this court over myself and over the subject matter. There was no injured party in this case. There is no probable cause statement. There is no grand jury. A grand jury was convened, but they did not indict.
So now you're talking about the substance and merits of the underlying case against you. That's a little bit different than speaking as to the competency hearing and the fact that you disagree with the results from Dr. Loring, right?
I don't only disagree, I object to her saying that I failed to
I get that.
participate.
Now, if you're going to tell me why this case shouldn't be here, why I should throw it out, why you should be released, why there won't be a conviction, that I don't want to hear. I can't hear that at this point. You have standby counsel. I want to protect you from yourself, and we're still in a competency evaluation phase here.
As a criminal defendant, I believe I have rights.
Of course you have rights.
And I have a right to address the court. I have a right to object. I have a right to a notice and demand for dismissal for lack of standing, subject matter.
So now
jurisdiction, personal
you didn't like my response, and now you're trying it a second time. You have rights. Right now, you're in a competency phase. There may be a later time, and hopefully within a couple months, we have determination, within a month, of whether you're competent to proceed. If you are, I will let you be your own lawyer again, and you can make legal arguments that may have traction as to why the case wasn't brought up against you properly, why there's been no victim, why the state can't prove the charges beyond a reasonable doubt, and I should throw some or all of them out. Today is not that moment. You've got standby counsel, we're in competency evaluation phase. I'm not gonna hear this right now, Mr. Hillygus.
Do I have a right to defend myself? And do I have a right to file documents that I've created in the jail that I'm at? Washington
So
County
by
Jail?
law, once there's a competency issue has been raised, the case is stayed. It stopped. Other than for competency hearing or things that need emergency review, like the request for the gag order or to stop the jail calls. Other than that, the merits of the case, the strength of the case, evidence, witnesses, whether procedures were followed in justice court and bringing you over here, that is not what we're here about right now. Here we're to decide whether you're competent to proceed to adjudication. And then, if and when that moment occurs, then we will move forward with the case, and you can make arguments that you think have traction that the court ought to decide.
I would object to your order for the competency evaluation as lacking jurisdiction, and I want that on the record, because you did not have jurisdiction over that, because you denied my ability to speak at the hearing on February 2nd. You denied my ability to express myself.
All right,
Therefore,
I
you lost jurisdiction because I challenged your jurisdiction, and you
Okay.
have not proven jurisdiction through the record.
Okay, I understand your position, sir.
Okay.
Thank you. All right, here's how we appreciate that. Here's how we leave this, right? We have another date to hopefully have finality on the competency hearing. The issue on the gag order, limit of jail calls, the court will address by written order. The issue of the prior writ petition that Mr. Handte brought as his own self-represented, that has now been briefed, the court will rule on that. I've apologized for making Mr. Handte concerned that he was gonna have to stay in the jail over the Easter holiday. I've reminded him no direct emails with my court or the court staff. Other acts, hearing. The other acts issue to set for hearing. Now the question is, do we set it at the same date and time, since counsel will already be here for Mr. Silverberg and Mr. Handte? Do you want to use that date we have to also hear that motion?
Yes.
What do you think, Mr. Silverberg?
Sure.
Because you're already going to be here, so we'll make sure.
Sounds like I will be, yes.
Okay, so it's order of the court then that oral argument on the other acts motion will be heard the same time that we also hear on Mr. Hillygus' competency
May
reports.
15th, Judge?
Say it again, yeah,
May 15th?
9 o'clock. And I'm gonna assume we're gonna use the entire morning, and, we'll take breaks as needed, but if we have to go through like we are through the lunch hour, people should please arrange their calendars to be able to handle that. All right, with that, that'll conclude this hearing. Thank you, everyone. Appreciate your input. Court's in recess.
All rise.